Hi, everybody. Welcome to our Tech Conversation series. Very happy to welcome Spencer Overton, I should say Professor and President Spencer Overton. You're going to put your questions in the Q&A and we will have time for that at the end. So let me just first introduce Professor President Overton. Spencer is the president of the Joint Center for Political and Economic Studies, which was founded in 1970 and is known as America's Black think tank. And he's also a professor of law at GW, George Washington University in Washington. Spencer has spent time at another think tank. During the Obama administration, he served as Principal Deputy Assistant Attorney General in the Office of Legal Policy, which is known as DOJ's think tank. And there he worked on voter protection and empowerment, which I think, Spencer, is your sort of main field. And in all your work at the White House and at DOJ, and now in your role as an academic and a leader in civil society, you've advanced democracy initiatives. Spencer has also practiced law at the firm of Debevoise and Plimpton. He clerked in the U.S. Court of Appeals for Judge Damon Keith and graduated with honors from Hampton University and the Harvard Law School. Spencer is the author of the book Stealing Democracy, The New Politics of Voter Suppression, and lots of other articles, both popular and academic, on voting rights, race, and public policy. And I think most relevant for our conversation, Spencer has written about and testified before Congress on online disinformation and voter suppression. So without further ado, Spencer, I think just to shape our audience's and voting rights, and then move on to section 230, which I'll explain what that is, and civil rights laws. And then we'll close up with a discussion about technology, your technology agenda more generally.
Okay, sounds great. Ellen, thank you so much for inviting me. You know, I've got so much respect for you and your work. I also admire Rutgers. I've got many longtime friends there who I turn to for advice, including, but certainly not limited to, Elise Bodie, Rachel Godsill, David Trout. You know, the list could really just go on. Now, the Joint Center you talked about, it was founded in 1970. That's just 5 years after the passage of the Voting Rights Act. The organization was founded to help a new generation of Black elected officials move from being outsider civil rights activists, agitators, to insiders who could really navigate governance. The organization eventually became, as you said, America's Black think tank. And, you know, it certainly had some significant accomplishments. Now, we reorganized the Joint Center in 2015 to focus on issues that have a big impact on the future of Black communities, issues like workforce policy, economic issues, diversity among congressional staff and presidential appointees, and also tech issues like platform accountability, broadband access, and we're just starting to think about the implications of privacy, data, and algorithmic bias for Black communities. Our strategy, Ellen, is to master these narrow topics and then add some issues. Kind of, you know, Amazon starts with books and then they spread out here. Now, most other think tanks do not center Black communities, and many of them don't have Black experts, right? Also, most Black advocacy organizations lack extensive research capacity. So that's the space that we try to fill. Black community organizations and advocacy groups cannot really be at the policy table in a meaningful way if they're just using someone else's talking points that are designed for somebody else, right? So the Joint Center's work, I think, really gives agency to Black communities.
Oh, that's great. And so now let's talk about one of those verticals, which is you know, technology generally, but more specifically, let's talk about disinformation and social media platforms. So, you know, since you come from a voting rights background, how do you see disinformation and basically social media platform policies figuring into the voting rights agenda?
Right, and you're right. Certainly my scholarship is focused on campaign finance and voting rights. And my recent piece on voter suppression and disinformation was really an avenue for me to get more deeply into digital platforms. And my take is that the platforms have magnified problems that already existed, largely through velocity, anonymity, and also the viral nature of disinformation, as Nate Persily would say. So for example, we had deceptive practices before where like homeless people from Philadelphia are bused to Baltimore and they're paid to drop misleading paper flyers about voting in Black neighborhoods, right? But this practice was taken to a whole new level by the Russians in 2016, imposing as Black folks who were posting and then targeting Black voters with disinformation in terms of directing ads at Black users, right? Also, allegations of illegitimacy and fraud have been used to delegitimize the votes of people of color in places like Wilmington, North Carolina in 1898, where a multiracial coalition won control of a city government at the polls, and then a white mob engaged in a coup and took control of the city government. And, there was no recourse or, no real response. They just took it over. Now, these allegations of illegitimacy were taken to a national level in the January 6th insurrection. Now, part of that was social media and platforms. Obviously, there are other media like cable news that contributed to that, but certainly that disinformation was all a part of it. And also allegations of fraud have been used to justify restrictions on voting, like photo ID and voter purges, which may prevent many legitimate voters from casting a ballot. But we saw it at a new level after the 2020 election. There were new restrictions in 19 states that made it more difficult to register, vote by mail, vote early, according to the Brennan Center. And 2021 alone accounted for 1/3 of all the restrictive voting laws passed in the last 10 years. So, those challenges, I think we've seen, just a new level has been accelerated through digital platforms.
Yeah, and I think your point that there's a through line, right, from disinformation to the actions we're seeing in the states with voter disenfranchisement and voting restrictions, because it's all sort of fed and justified on the back of this kind of these disinformation campaigns, fake accounts, bots, manipulation of the discourse.
Yeah.
And sorry.
No, one thing I did want to say is yes. I wanted to acknowledge, though, that these platforms have helped in many ways, right? They've helped in terms of mobilization. They have facilitated voter registration and voting here, the I voted sticker being on someone's page. And one thing that many people ignore is that this is a low cost way to target a group. So it's cheaper than television, right? Like, I want Latino candidates to be able to use these tools to mobilize Latino voters. Agency by community is important, right? So it's not just a Facebook saying, okay, we registered this many voters or we helped this many people vote. Actual agency by third-party entities to engage others to participate in democracy, is valuable. And that is something that has been facilitated here. And, I think other people may not share my perspective, but I really am concerned that broad political bans here in this space might end up allowing, targeted ads for Disney, but not for a Black candidate to be able to buy ads and target those ads to, potential Black voters. So there are some good things about these tools in terms of facilitating democracy as well, and I don't think that we should overlook them.
I'm so glad you said that, Spencer. I mean, it's right. It's a both and thing. And I mean, I appreciated in one of your letters to Congress after there was a hearing and you were asked follow-up questions. And this one was on micro-targeting, because there was some interest in Congress in banning micro-targeting for the reasons that you said, that it helps sort of target misinformation to to vulnerable populations or to populations that are trying to be, demobilized. You said political ad micro-targeting can be used to spread disinformation to marginalized communities that sows confusion and discourages the communities from participating in the process. It can also be used to mobilize marginalized communities to participate in the political process. And so, I think, and I know we're going to get into kind of the competence, the institutional competence of Congress and other actors to deal with these problems, right? But so what you're pointing out there is that, in a way, the technologies are neutral, but we have to pay attention to how they're being used. So maybe we can talk a little bit about Section 230 and the to and fro on that, because I think it's a great example, right, of just for our viewers and listeners, just like a quick word of what Section 230 is. You've heard about it, but some people may be a little bit vague on what it is. So Section 230 is part of the 1996 Telecommunications Act. Significant that it's that old, right? It was passed when the internet was a baby. And so what it does is give the platforms and all internet services actually immunity from liability. So they're not responsible with respect to third-party content. So that means Yelp isn't held responsible for its reviews. Facebook isn't responsible for its posts or the posts of third parties. And at the same time, these platforms and websites can exercise moderation and curation, which they all do, without worrying that they'll be liable for their decisions one way or the other. And notably, Section 230 has a carve out for federal criminal law and a few other things. So the platforms can be liable for content that violates federal criminal law, but not for federal civil rights laws. So if that content violates the Fair Housing Act or voter protections or anti-discrimination law, the platforms are not going to be responsible for that. And just the last thing I'll say before asking you a question, Spencer, is that, this is one of those laws that was passed at a time when people were mostly focused on the good that the internet could do, right? And how it could bring people together. And you could have this new forum for speech for people who had been shut out of, the conventional media environments. Was supposed to be empowering. And that's what Section 230 was supposed to protect. After 2016, people began to question from both the right and the left whether it was giving too much protection. And so the right worried that the platforms were deplatforming alt-right and other provocateurs. And the left worried that the platforms were not taking enough action to keep hate speech and disinformation and other harmful content off the platform, and indeed we're amplifying it through their algorithms. Okay, so now I can turn it over to you, Spencer. What has been your and the Joint Center's position on Section 230?
Right, and especially since we're at a law school, and law schools were about disagreement, and I'm going to disagree with you here, right? And here is my disagreement with you. I think we've got this recorded, so I might be wrong. I feel like, or think, not feel like, I think that you parroted Facebook's argument that civil rights laws don't apply to, for example, housing and employment ads that are targeted toward white folks and away from Black users. Facebook's argument is that 230 immunizes them, right? Now, my argument is that 230 does not give immunity when platforms make a material contribution to the underlying legal harm, like when they engage in discrimination, when they select, let's say this is going to go to white folks and not to Black folks. Now, certainly the law is unclear, the case law is unclear. There are cases like roommates where there was some data that was collected, and the court basically said, and it was for housing, like apartment matches, that kind of thing. And some of the information was, do you have children? What's your gender or sexual orientation? And the court actually found that the roommates collecting that information and then matching people based on that, it was making a material contribution to the legal violation. And as a result, it didn't get the 230 protection, basically. It was not immune from state civil rights compliance here, right? And so I'm making a similar argument in this scenario, in this case, that Facebook makes a material contribution to discrimination through its data collection and algorithms that determine which users see which ads by predicting which users will engage with the ad, right? The third-party advertiser doesn't even know who will see which ads. They're not in control of who sees the ad. A Facebook would be. Now, there are some cases like Craigslist where there's just something that's posted, a discriminatory housing piece, and everybody can see it. And the platform's not really engaged in determining who sees it. And in Craigslist, they said, hey, there is immunity. There's no liability because of 230. And I get that, right? Everybody sees it. All Craigslist is a pass through. I think that you made this initial point that the internet is so much different. It's just very different than it was in the late 1990s. And part of how it's different is that you've got platforms that are using data and algorithms to determine who sees what, right? And so they're participating in a way that they didn't before. And my take is that this discrimination context is particularly kind of relevant because when, you know, the Black folks don't see the employment or the housing ads and the Latino folks don't see those ads and white folks do, that you're participating in the underlying legal violation in terms of the discrimination. Yeah, you're not posting something that says no Blacks allowed, right? You're not doing that, okay. But you are making a contribution to the discrimination and maybe even more so than the original third-party poster that's not controlling who sees the ad here, right? So I'm sorry to get into all of that in terms of back and forth, but that's the basic argument. Now, I haven't had conversations with a lot of, for example, state AGs about this. I know that state AGs have tried to say that they should be able to enforce consumer protection claims unsuccessfully. You know, basically Section 230 was used to bar them. You know, but at the end of the day, Ellen, my real target here was Congress through state legislatures. And here's what I mean. My explicit argument was state legislatures, you should not be chilled from passing voter deception and civil rights laws covering platforms like Facebook due to 230 because they're making a material contribution to content dissemination in terms of in a discriminatory way, right? My secondary explicit argument was, hey, Congress should provide a carve out, just to be clear, they should provide a carve out for civil rights laws, just like there's a carve out for federal criminal law, intellectual property law, the Electronic Communications Privacy Act, sex trafficking, et cetera. Fordham law professor Olivier Sylvain made a similar argument. You know, the thought here is that, you know, intellectual property being carved out, yeah, you know, communities of color are just as important as the Motion Picture Association of America, right? That they should be deserve a carve out as well. My implicit argument with all that, those were the explicit arguments. The implicit argument in the piece was Facebook and other companies, you don't think you have much incentive to reform 230 in Congress, but you don't want 50 different regulatory regimes in all these states passing these laws. Rather than avoid Congress, you should engage Congress in serious and strong 230 reform that includes preemption so that you have one set of rules with which to comply, much like you're trying to do right now in the privacy sphere.
Yeah, okay, so first of all, I agree with your reading of the material contribution. And I think, you know, so the question, and actually our co-dean former co-dean David Lopez was very involved in that Facebook litigation on housing and employment. But I think, so the question is, you know, when is Facebook materially contributing? And there are all kinds of bills now that are trying to get at that through, what is algorithmic amplification? Is anything other than any kind of curation other than, or monetization, which is really what we're talking about, right? When they're taking ads, is anything other than sort of a broadcast approach or a reverse chronological approach? Does that count as material contribution? Those are all really interesting questions. And I guess, do you think that the Congress is the place to sort that out? Do you think we need a regulatory agency that can deal with that? Is it the state AGs?
Right, yeah. Well, what's also funny about this is, when I started to write this piece, my initial thing was, okay, the solution is a carve out, a federal carve out, right? That was the solution. And I was like, you know what? Don't give up this argument about material contribution. Like, there is a real argument here. Let's go ahead and make it. And indeed, by making the argument about why there's a material contribution, you're kind of implicitly making an argument to Congress about why you need to be explicit about a carve out, right? Like, they're really engaging in behavior that's connected to discrimination here. So again, I think it is so that it's so easy to do that. And I just don't, I certainly initially conceded it, and I stepped back from it in terms of writing this article. And I always have to be careful to say, hey, let's not give this up in terms of the state piece, in terms of material contribution. But yes, so I do think that Congress should be explicit in terms of a carve out. I think that there has been an uptick in 230 reform in Congress, not just because of my article, but because of the good work of other organizations like Public Knowledge. And interestingly, because of, President Trump's very different calls to reform 230, right? In a way that would limit the power of companies to engage in responsible content moderation. And this is, as you said in the beginning, 230 basically immunizes companies for what's put up on their platform, but it also immunizes them if they decide to take down some content. So they are really free to engage in content moderation in a responsible way without worrying about that simply by taking something down, they're opening themselves up to a lawsuit and to liability. Now, I oppose former President Trump's proposals to revise the statute. He would eliminate the power of platforms to remove so-called otherwise objectionable material, right? And I disagree with that proposal, because I think it would, by restricting the ability of contents to engage in responsible content moderation, that would promote a lot of disinformation on platforms that leads to voter suppression, racial animus, civil rights violations, a whole bunch of other issues. That otherwise objectionable is kind of a catch-all term that, some of this behavior does not fit into other parts of 230. So I want companies to be empowered to engage in content moderation. Now, there are a couple of reforms I focus on. One is the Civil Rights Modernization Act. It's relatively narrow. It gives a 230 carve out to civil rights claims based on targeted ads. In other words, it says that platforms can't argue that they're exempt from federal civil rights laws when they take money and then they target or deliver ads along racial lines. That doesn't say that they're automatically liable. It just means that if a lawsuit is brought, they got to go into court and explain why the elements don't apply, right? They can't just say, we don't even have to show up because it's 230, right?
Yeah.
So now,
which is what happens now. They don't show
right.
up.
Right. They just phone it in here. Here's a motion, motion to dismiss it. Now, the Safe Tech Act is started out in the Senate. It's a different bill. It's much broader. I like the fact that it has a civil rights carve out. Anytime a law professor's suggestion gets picked up in a bill, you're going to endorse the bill. But the bill also says that Section 230 doesn't apply to ads generally, not just for civil rights purposes, but And my concern is that this could possibly chill platforms for allowing ads that are important. I mean, if you think about targeting truthful information about COVID vaccines to under-vaccinated populations, basically all ads lose 230 protection. So, this is an empirical question. I don't know how real it is, but I could see how that's a much more difficult question than simply doing a carve out, civil rights carve out for ads. In terms of some of the other reforms to 230, the Joint Center is currently working on that. I'll give you an update later. We're working on a report that on the impact of various 230 reforms on Black communities. Oh. The co-authors include Fordham professor Catherine Powell and civil rights lawyer Michelle Aronowitz.
Great. I mean, so let me ask you, so where we are now, we've got all kinds of proposals and we have a kind of, Congress is hamstrung as it is in so many areas. We have some movement at the state level, actually in both directions, right? We have states kind of picking up Trump's proposals in, I think, Texas and Ohio, and we have other states that are trying to advance protections for civil rights. And we have, the other solution, we have courts trying to work it out, which is, of course, how we got Section 230 in the first place, right? Which was a congressional response to common law developments that they didn't think were healthy for the internet. So that's always a path. But where we are now is we're relying on self-regulation. And I know that, Facebook did a civil rights audit. I can't remember if the Joint Center was involved with that or not,
we participated with Laura Murphy and engaged with her. She did the audit of Airbnb and the audit of Facebook, and we were very much engaged in terms of providing feedback to her. Yes.
So how do you view those processes? I mean, how promising are they? That sort of self-regulatory consulting civil society stakeholders, but not being bound to them.
So I think this is like a big message in terms of your students, right? For me, the first year I started teaching was when Bush v. Gore came down, right? It was 2000, right? And so a whole new area of law effectively opened up that was new in terms of new questions. And I really think that your students are going to be in the cutting edge in terms of the evolution of law in this space. Throughout history, we've had industries, whether it is this invent of the cotton gin and the rapid expansion of slavery throughout the South, where, cotton makes up over half of our exports and is responsible for, the base of the US economy, just after basically the ratification of the Constitution here, right? And we have this industry and an industry that that basically externalizes its costs onto a population. And we're still living with the costs of that today in terms of some of the racial challenges. We look at the Industrial Revolution, other aspects of the Industrial Revolution and global warming. And yes, I love technology. I love air conditioning. I love everything that comes with that, but there are some externalities that were not internalized by those industries, and we're struggling with them. And when I say we, I mean law is struggling with those today in terms of how to deal with them. And so in this tech space, the first issue is always like self-regulation. Oh, well, we can handle it, right? Disclosure, self-regulation, just trust us here. And frankly, I'll just say it doesn't work because companies are focused on, it's not just money for money's sake, they're focused on innovation. They just have different incentives. And this really is the role of law, as it is in prohibiting slavery, as it is in, regulatory regime with regard to environmental law. This is an emerging area, and the question is going to be, what is the role of law in this space? And it's overly simplistic to ideologically say that it's all about just heavy regulation and restrictions, or no regulation and just some disclosure maybe. that is a shortcut to really thinking through difficult issues and grappling with them, right? This isn't the thing that a talking point is made on. This is the thing that careers are built off of. This is the thing that students move into at this age in their lives, and they are ahead of the curve because other people maybe who are more senior don't understand the tech as well, or those other more senior people have, a caseload that's already full, so they don't have the freedom to maybe move into new areas. And this is an area where students can really help define what is the role of law later on. So there are definitely some big principles, that are at play, and we'll talk about them a little bit more a little later, but at least some disclosure in terms of this space, but not just disclosure, certainly agency. How do we figure out an agency approach to this? Congress is slow. It doesn't have the expertise. These areas are always evolving. You need an entity that is much more flexible and fluid and responsive to deal with these changes. That's, I think, an agency. And so the question is that one agency that really understands tech? Do you take an agency that already exists, like the FTC, and kind of put it in the lead? Do you do it by subject matter and say, okay, HUD, you'll deal with housing discrimination, EOC, employment, the Consumer Financial Protection Bureau, credit issues, so I think that it is, there's a question about how we do it, but I think that agencies have a significant role in terms of the regulation of tech and the development of law in this space.
Yeah, I agree with that. So let's just broaden out from social media platforms to other kinds of algorithmic systems. And I know the Joint Center has looked at some of these issues, and I know our listeners are aware of the fact that, algorithms or AI or algorithmic decision systems have been sort of shown to be, while they can improve justice and access to opportunities in many ways, they have also been shown to be biased. They replicate sort of past patterns of injustice in fields of hiring, policing, credit scores, housing. And so, and this I think goes, Spencer, to your point about incentives, right? So the companies that deploy, or in the public sector too, that deploy these algorithms are, sort of incentivized to optimize for a particular function, and are not necessarily sensitive or don't have or have not been tasked with caring about justice issues, fairness issues, things that are outside of the scope of what they're trying to optimize. Yeah.
And they're not internalizing all their costs, right? Mm-hmm. They're externalizing some costs here, and they're just totally ignoring that, right?
Yeah. So what do we do about that?
Well, my thinking just kind of first on this is very much informed by the work of Jessica Eaglin. She's a professor at Indiana University. In short, she observes that there are two schools of thought on this issue, right? She says they're the fixers and the abolitionists, right? The fixers want to fix algorithms so they don't perpetuate discrimination, and they feel like a fixed algorithm solves the problem of discrimination, and we won't have any, solution here to the promised land. The abolitionists want to abolish algorithms because they feel as though they're simply another tool of state and corporate control that facilitates mass incarceration, corporate profits, and control of workers in marginalized communities, right? Professor Eaglin, she disagrees with both of these camps. She says that, they're incomplete in their framing of racial inequality. The problem's not just about individual actors acting on individual bias, but broader systems and assumptions that shape racial subordination. She said that both of these groups fail to seriously grapple with policy impacts on people of color throughout the law generally. And because of this, both camps would likely perpetuate structures that marginalize people of color, rather than seriously address intergenerational racial inequality by investing in, economic and social opportunities, et cetera. So in other words, tech is not a substitute for law in reducing racial subordination law has a real role to play and should not simply cede, its role to technology here. Tech is not a silver bullet in preventing discrimination, that's been built up over the last 400 years. Now, that doesn't mean tech doesn't matter, right? It's better, obviously, to build algorithms that use data sets that have less discriminatory impact. And, so there are a variety of bills, state, federal bills that are out there. We're just starting our work in this area at the Joint Center. I can't say I'm for one particular bill over another. Some important principles, though. The concept of discriminatory intent as well as discriminatory impact are incomplete. We don't want to be limited to discriminatory intent. A lot of discriminatory decisions are made through machines and don't involve racially discriminatory intent. Indeed, companies often cloak discriminatory decisions with kind of this patina of fairness and objectivity by suggesting that the algorithms are somehow objective and neutral, really, as you suggested before. But on the other hand, disparate impact is limited because it's often justified by business necessity, which is subjective and can be discriminatory. To give you some examples, the uncompensated labor of slavery was arguably a business necessity for the US to displace China and India as the dominant producer of cotton, right? Redlining was a business necessity to ensure higher returns on loans by focusing on white areas where appraisals were higher because few whites wanted to live in Black communities. So, I think kind of the traditional paradigm, we've got to kind of rethink that. I mentioned to you disclosure, I think, is important. In my piece, I talked about algorithmic accountability in EU under the GDPR and the possibility of requiring that companies use data protection impact assessment tools to identify the risks of discrimination and make revisions, right? Pre-clearance, as you'll remember, was an important tool in voting rights. It's an important tool in antitrust enforcement, and some sort of pre-deployment review of algorithms to prevent discrimination could be valuable. And then, we talked about agency authority and beefing them up. And then also finally, technology is always changing, and federal law may need to empower state attorney generals or attorneys general rather, and private litigants to protect civil rights in the area. So those are some kind of starting principles or ideas or concepts. And I know there's already some work, but obviously we have much more work to do in this area at the Joint Center as well, and as our nation as a whole.
Yeah, I really appreciate Jessica's work, and also our former Ripple fellow Rashida Richardson, who's now in government, has also done really important work on the intersection between racial justice and algorithmic justice. And I think you point out, Spencer, that these are complex sociotechnical systems, right? And so I think I absolutely agree it's a mistake to kind of look at algorithmic justice as if it's an data problem, right? And not embedded in larger systems. So some of the most interesting, I think, inquiries are about, why are you using this tool? What's the point? What do you think you're after? What are the goals? Who's involved? Who makes the decisions? What is the human component here, and who is affected by it? So let me encourage people, now is the time to put your questions in the Q&A. And our last two topics, before we get to those, I wanted to spend a second, Spencer, as we sort of talked about earlier, on the metaverse, and sort of, if 1996 was early days for the internet, and we've all been surprised, like what's in store for us, and how do you see sort of your mission kind of to the extent that any of us can imagine that, but like, what are the patterns of inequality and injustice that we need to watch out for in the metaverse? Do they get replicated, or do they get, trying again to see the bright side? Right. Is there a possibility for redress and addressing them? And then the final question, just so people know, is I want to talk a little bit about your career trajectory and how you got to where you are.
I appreciate it, Ellen. So what I want to do is quickly just flag this piece here. Very proud of my sister, Dr. Cynthia Overton. The name of that piece is Who's Building the Metaverse? Being Intentional About Inclusion During Black History Month and beyond. So, and I actually talked to Cynthia about this just this morning here, and we've been talking for a while about this topic. So no one knows what the metaverse is going to look like, and so it's not surprising that it's going to be difficult to regulate something that's so amorphous. We can think about case scenarios, when you think about the ability of people to be teleported, will Black people be able to go everywhere? What will advertisements look like? If virtual vending machines pop up, will there be one price or different prices for different populations? Can we expect Meta, Facebook to do the same in Web3 as they did in Web2? Investors and companies are also giving out major money in this space. If we're not proactive in terms of marginalized communities being invested in terms of Web3, even if there's not intentional exclusion, these communities are already behind. Cynthia's basic premise is that Web 1 and Web 2 really got it wrong in not being intentional about being inclusive. They just thought that race doesn't matter, and the result was exclusionary spaces and discriminatory practices, right? And will we be intentional is her big question about Web 3 here. She thinks companies should engage Black talent in developing their metaverse strategy, also their digital assets that they're selling here, support Black employee research source groups so that they're there's professional development support. Obviously, we all think using AI responsibly is important. Protecting the safety of users. Cynthia adopted a new avatar because as a Black woman, she was actually assaulted. So she goes around as Big Chuck now, who's kind of a middle-aged, balding white male here, and she doesn't have as much of a problem here. She thinks that leaders in the space should follow Web3 thought leaders, invest in Black-led entities and Black-created NFTs, and include Black founders at Web3 conferences and on podcasts, that kind of thing. One thing that's unique and different is, and concern, is the decentralized nature of Web3, right? So the community wins out here. So will it be a scenario where decentralization is a negative, kind of in terms of federalism and states' rights, where folks use decentralization to facilitate discrimination, right? Or will communities be built where the norm of discrimination is bad, including structural exclusions, systems of exclusion, right? So not just individual discrimination here. So will it be like our country was immediately after the murder of George Floyd, where all sorts of folks from all different backgrounds were being intentional about being exclusive? Or will it be like the appalling silence of the good people that Martin King referenced, right, in criticizing the complacency of the white moderate and ignoring the evils of segregation? So we're at a fork in the road, and it's really our decision about what steps we take in this moment.
That's really a beautiful way to put the challenge. We do have a question. I think you've already answered it, which is, are you concerned that removing Section 230 would stop the platforms from micro-targeting ads that we might want micro-targeted to encourage? And I think you said you were worried about that.
Yeah. Exactly. I'm a reformer rather than an abolitionist in terms of 230.
So we've got 2 minutes, and Spencer, just talk us out with kind of why you became a lawyer, and then kind of what you've seen as the threads that you've pulled through your career.
Okay, very frankly, I became a lawyer because I felt like a young, kind of marginalized Black male, and I just felt like this was a way to not be just kind of marginalized as much, to just have some ability to talk and to not just completely be at the whim of others. That's the reason I got into law. And I was very fortunate because it was so flexible and there was so much I could do. I initially thought I was going to go home and be a politician. I went home to Detroit and I recognized I didn't have the stomach to like steal lawn signs or do other things, right? And that, I was really interested in ideas. And so fortunately, being a law professor was great in terms of ideas and being around, young folks who were thinking about issues. And so that developed. And then obviously now I'm at the Joint Center. And my goal here is, it's great for me to be a public intellectual or write books, but if I can create a platform where I'm empowering others to do that, like that is my goal. That's kind of my calling. So when I was in law school, I could not really see being where I am now. But when I look back at what I was really interested in and what really moved me, I'm not surprised at all that I'm here. I'm very happy and very content with it. But it just took me time to figure out. I didn't know that a think tank existed. When I was in law school, I hadn't thought about being a law professor. I didn't think about running a think tank. But even though I was definitely interested in justice, I was definitely interested in ideas, etc. So sometimes it's just time. And I'll tell you, there's so many experiences being at a big firm in terms of Devil Voice. I learned so much, and I'm not intimidated by companies. And, there's a certain kind of work ethic that I have on behalf, I think, of the community as a result of that experience. And so I think all of these experiences kind of help round us out and give us tools to, advance our purpose, on the planet.
And is Cynthia a big sister or little sister?
She is a little sister, but she would also remind me that she is a real doctor, and that because I only have a JD, I am not a real doctor, right, since I don't have a PhD.
So we have to thank Cynthia for her guest appearance, and also GW and the Joint Center and Spencer Overton. Thank you so much for being with us.
Thanks, Ellen.
Take care.